Hi, everybody. I'm Professor Bobby Chesney from the University of Texas at Austin, where I direct the Strauss Center for International Security and Law. And with me today is Professor Matt Waxman of Columbia University, where he directs Columbia's National Security Law program. UT and Columbia have teamed up to curate a series of lectures on national security law, covering a growing array of topics, and our hope is that this will be useful to people in general, but especially to students. We're in the midst of a 3-lecture series from Matt on the Constitution and war powers. Right now, we're about to begin the third and final in the sequence, and it's about the power to end war. We'll go for approximately an hour and a half, and then, if possible, we will reach questions that those who are attending live can pose through the Q&A function. We'll see how the timing goes. So without further ado, Matt, I'm going to turn the floor over to you. Let me just thank you in advance for this wonderful series of lectures you've been giving us.
Great. Thanks very much for having me. Let me go ahead and share my own. This lecture is actually going to be about waging war, though I'm going to get at the end to the war termination question. The first 2 lectures in this series covered foundations, what was the original sort of founding charter of the Constitution supposed to do with regard to war powers. In the last lecture, we talked about going to war, often, I think, mistakenly talked about as the most important war powers question. In this lecture, we're going to talk about what I think is the most important issue, which is constitutional powers to wage war, and it is hoped to win wars. In this lecture, I want to cover 5 things. The Constitution and waging war. The bottom line here is that there are very few hard and fast rules. Congress's legislative war waging powers. The president's war waging powers, how those 2 interact, especially when they're in conflict, and then ending by talking about how war and with them war powers terminate. And this is not, let me be clear, this is not a comprehensive treatment of these issues. It's more like a sort of greatest hits album of some of my favorite examples that I think illustrate some important points. And they're mostly drawn from some of the largest, most major wars in which the United States has participated. Like I said, in my view, this is a more interesting and consequential story than lecture 2 on how we go to war, especially the issue of Congress's war powers here, how they grew, what Congress can do other than to decide whether or not to go to war. Now, I want to start with an episode that many of you will be very familiar with, or at least read in maybe a con law class, and that's the famous Steele seizure case. So the story goes basically like this. In the middle of the Korean War, President Truman faces a dilemma. The steel industry is facing imminent labor strike, and the administration regards continued production of cheap steel as critical to that war effort, as well as to competing effectively in the Cold War. But existing statutes didn't provide adequate remedies, at least not in Truman's mind. So he takes the dramatic step of seizing the steel mills in order to keep them running. And when the steel companies sue, the case quickly goes to the Supreme Court, which strikes down the president's move. Most members of the court reject President Truman's arguments, his claims of constitutional power to seize the steel mills. I'll talk more about the holding in a moment, but to me, I want to talk about some other aspects of the case. And to me, one of the most remarkable features of the case is how divided the court was over even how to analyze the case, let alone how to resolve it. You know, how do we think about implied powers of the president in wartime, for example, or was this even really a war? You'll remember from the previous lecture that Truman doesn't claim that he doesn't go to Congress for a war declaration. He says that this is a police action or an emergency action. That may come back and haunt him a bit in this case. And if you read Justice Jackson's opinion, he had served as Attorney General to FDR in the lead up to World War II, you see in his opinion, he's really complaining that, or lamenting the fact that there isn't a lot of good doctrinal guidance on even how to analyze this case. And I think the same could be said today, almost 70 years later. There's a lack of clarity of law in this area and a lack of helpful judicial precedent. Also running through this case, the various opinions. There are 7 justices who write separately. There's a big divide on sort of a fundamental and most general level question that I think repeats and comes back again and again throughout history. And that is one about how is the Constitution in general supposed to operate in wartime? Is the Constitution supposed to bend flexibly to the imperatives of war? Or is the Constitution supposed to remain rigid in the face of all kinds of pressures, including political pressures that might arise in war, because the danger of bending the Constitution amid the frenzy of war is too great. So I'll return to that big debate between flexibility and rigidity later. For now, though, let me turn to Justice Jackson's famous concurrence in this case. He leaves us with a framework. It's a very general one, but it's been very influential and is often used today for thinking about war waging powers. So he tells us that the Constitution diffuses power, and the president's powers aren't fixed, but fluctuate depending on how Congress is exercising its powers. The upshot then is that it's helpful, if we want to think about war powers questions, to at least start by examining what are Congress's powers that it can bring to bear on a question, and what are the president's, and then we can think about how do they combine. Again, what I'm going to talk about here is not comprehensive, but we'll give some examples about how the president's powers and Congress's powers combine. Because Jackson instructs us that when the president and Congress are operating sort of in the same direction, the president is operating with agreement of Congress, his power is at its apex. If he's operating independently, where Congress is silent, well, then the Constitution's especially murky. And when he's operating contrary to the express or implied will of Congress, his powers are at their nadir. We'll talk about those various categories through the use of some examples. Before turning to examples of Congress's war powers, let me just review some basic text. I went through this in a lot more detail in lecture 1 on foundations, but just to remind you, when it comes to war waging powers, Congress, Article 1 has a lot to say about military power. Some of the most significant provisions for our purposes here in this lecture include that Congress has the power to declare war, as well as to make certain kinds of rules about things like captures. Congress has the power to create military forces and to make rules for governing them, to provide for calling forth the militia and for setting standards for the militia. We're going to talk about each of them and how they operate in practice. Congress also has this important catch-all, and we don't normally think about this as a war powers provision, but it becomes a really, really important one that does a lot of work, especially when war becomes total, which is the necessary and proper clause. Those were the formal express powers of Congress. But before going on and talking about Congress in practice, let me make a general point, which is that if you just focus on Congress's express powers, and if you just focus on statutes that Congress actually passes, I think you're missing a lot of the action, a lot of what Congress does in overseeing wars, overseeing military operations, or at least you're missing out on a lot of what Congress could be doing in this area. And so I want to talk about where this oversight and investigatory power comes from, because it arises, an important precedent is set very, very early in our history. In fact, it's set following one of the US military's worst battlefield debacles, just soon, very soon after the Republic was established. The first significant military hostilities for the new United States began before the Republic was even established in the years following the Revolutionary War. Relations between Native American Indians and US settlers had been worsening in the Northwest Territory, the sort of sparsely populated area beyond the Appalachian Mountains in what is today Ohio and nearby states. And when the Constitution is ratified in 1789, violent encounters are growing worse. So George Washington sends a small expeditionary force to deal with the situation. When those forces suffer heavy losses and the Native American tribes refuse to submit, Washington turns over command to General Arthur St. Clair, who is also governor of the Northwest Territory. Now, Governor St. Clair, or General St. Clair, was pretty ignorant of frontier combat, and his force was still comprised mostly of militia who were poorly trained. St. Clair, just to give you a sense of how bad this was going to go, St. Clair himself was suffering from really painful gout, and he had to be carried around the battlefield on a stretcher. So in the critical battle in November of 1791, about half of his forces, St. Clair's forces, are annihilated and the rest flee. This then sets off an important precedent for executive congressional relations in war powers. It results in the first formal congressional investigation of military operations. And exercising its oversight powers, the House of Representatives convenes a special committee to investigate St. Clair's military defeat. And that's big because this kind of oversight, the ability to call the executive branch to account, to investigate what's happening, that's important to Congress's ability to exercise effectively all of its other war powers.
Matt, you know, these days when Congress is investigating things that touch on national security activities, military affairs, et cetera, we sometimes see some significant clashes with the White House. How did President Washington respond to this sort of initial version of that sort of investigation?
Yeah, it's a great question because George Washington and his cabinet considered those issues very carefully, whether they were required to submit to this committee. The Constitution doesn't talk about these kinds of investigatory powers, but and Washington and his advisors were very conscious that they were setting precedent here with regard to future requests for documents, for example. And they decided, though, that they were obliged to comply with the inquiry because they said the investigation flowed implicitly from Congress's powers. George Washington and his advisors also agreed that although in other circumstances, they thought it might be proper to withhold some of the requested information, Washington should furnish all the requested documents in this case. And St. Clair and Secretary of War Henry Knox, they even testify personally. St. Clair is ultimately exonerated from personal blame. But even today, this remains an important precedent in executive congressional relations when it comes to oversight. So to me, the most interesting case, the most interesting war for illustrating Congress's powers, at least in their full expansive bloom, is World War I, or the Great War as it was known at the time. And now World War I doesn't get a lot of play in war powers lore. I think that's partly because, as I talked about in the previous lecture, it's a declared war. And if anything, it's remembered in kind of war powers of con law today as a story mostly about wartime restrictions on free expression. After Congress passed the Espionage Act of 1917, the Sedition Act of 1918, Wilson pretty aggressively prosecutes hundreds of cases against publishers and dissenters for allegedly interfering in the war effort. But First Amendment protections weren't very well developed at that time. I think the big issues for understanding war powers and Congress's powers to wage war are the issues of conscription and economic regulation. These were colossal domestic national powers legislated by Congress that were deemed necessary to waging modern industrial scale combat thousands of miles away. So I'll talk about each of them in turn. When it entered the war in April 1917, a war that had been consuming European soldiers at a terrible pace, the United States had only a few 100,000 troops, most of them on the Mexican border. The United States would eventually send more than 2 million soldiers to Europe during the war. So dramatic, order of magnitude larger army it needs to build quickly. And the political leadership knew that only a national draft, and more specifically a selective service system, could efficiently grow the force by that amount, while also, and this was key, keeping workers of critical industries in their jobs on the home front. And so in the end, almost more than 2.5 million draftees served during World War I, including over half of those who were sent to Europe to fight. Now, regarding the draft, a national draft, throughout American history to that point, there had been significant debate about whether the federal government could conscript soldiers, and additional doubt about whether conscripted soldiers could be sent overseas. And the strongest objection to that was not really one based on individual rights. It was really a structural argument about federalism, that mandatory national service, national military service, ran this argument, was an integral aspect of traditional state militia powers, protected by the Constitution's militia clauses in Article 1. Those clauses give states the power to maintain and train a well-regulated militia that can be called into service by Congress, and only for certain limited defensive purposes. And the argument was that to allow the federal government to directly conscript able-bodied men, most able-bodied men, would nullify state rights and protections that adhered to the militia clauses. And if you look historically in the War of 1812, Madison's Secretary of War, James Monroe, proposed a national draft, but it was defeated partly based on these constitutional objections. During the Civil War, the Union eventually resorts to a national draft, and the issue there gets litigated, but not definitively resolved, and it's considered very constitutionally questionable in the Civil War. But here in World War I, the Supreme Court unanimously upholds a national draft. It's very dismissive of those historical arguments and concerns about protecting state militias. And I'd note that before the war, Congress had exercised its army powers to turn state militias into much more of a uniform system of what today is the modern National Guard, a reserve force that could be inducted into the National Army when federalized. But the Supreme Court's approach here is essentially one of military necessity. It looks around the world and says, in 1917, 1918, you look at the way war is being waged and you look at the way states are waging it, national drafts are necessary today. I don't know whether they were necessary in 1812 or in 1863, but they're necessary today, and therefore the Congress's Article 1 powers to raise and support an army need to be interpreted very broadly. Now, there's an interesting coda here that in 1940, skipping ahead, the federal government enacts the nation's first peacetime national draft. So that means that in about 150 years, we go from a national draft being constitutionally doubtful, even in wartime, to complete acceptance as constitutional, that a draft is constitutional even in peacetime. I think that's a big story of evolving war powers with huge implications for individual rights and the relationship between state and national power. World War I, though, wasn't just about fielding and commanding huge armies. War was also about keeping them fed and equipped and keeping the domestic economy supporting them while also functioning effectively on the home front. And this required unprecedented intervention into the American economy. There were, like with the draft, precursors to this in the Civil War, but this was an entirely new level of government intervention into the economy. In his 1948 book, Constitutional Dictatorship, the historian and political scientist Clinton Rossiter describes Wilson's power this way, quote, Wilson wielded infinitely more power than has ever been given to an American president. In absolute terms, it far exceeded Lincoln's, for it extended to a control of the nation's economic life that would have caused a revolution in 1863, end quote. So among the most significant pieces of that legislative regulatory structure was, for example, the Food and Fuel Control Act, or the Lever Act, which gave the president broad powers to make regulations and to issue orders to assure adequate and equitable supply and distribution of those critical resources. And keep in mind the legal context here. This is not just very, very vast economic regulation, but also delegating it to the president and to new administrative agencies. And this was all taking place in what was still the Lochner era. So this went against peacetime limitations on congressional economic powers. It went against peacetime limits on congressional delegation of policy discretion. It went against peacetime understandings of Fifth and 14th Amendment rights to be free of regulation of so-called private economic activities. But as with conscription, all three branches, except during World War I, this kind of economic intervention as necessary. And I'd pause here to make the general point that today, war powers controversies are rarely about the extent and limit of Congress's war powers the way they were in 1917. They're much more often about the president's war powers. And I think a big reason why we don't think as much today about Congress's war powers is because Congress's other powers, Congress's non-war powers, have expanded so dramatically since World War I that all of these domestic economic regulations that were justified during World War I only as an exercise of constitutional war powers could, by the end of the New Deal in World War II, have been justified just as easily under the commerce power, even in peacetime. And at the same time, doctrines and exercises of non-war emergency legislative powers have expanded too. Congress today has lots of emergency powers, whether we're at war or not, and it delegates a lot of them to the president. So looking back, I'd argue that World War I was probably the moment in American history where the differential between the federal government's wartime powers and its normal peacetime powers was probably at its greatest. that once warfare became total in the early 20th century, legislative war powers became the basis basically for transforming largely laissez-faire systems into centrally administered statist ones, and for subordinating the state militia system into the federal government's power to compel directly men into military service. So in other words, legislative powers today, legislative war powers, that is, today, I think don't have to work as hard, in part because other constitutional powers now do so much more work than they did at that time. So on that note, let me talk about the president's war powers. And again, if we're looking at the text, it's pretty clear that the president can control the forces that Congress creates. That is, he can direct military operations. So he's commander in chief, but he's also got executive power and the power to take care that laws be faithfully executed. And the point that I want to try to illustrate with some examples here is that, as with Congress's war powers, as the nature of war changed, as US military strategy moved from a focus on territorial defense of the new United States to more ambitious war strategies, presidential war powers expanded massively too. And I'll try to illustrate that with 2.5 examples. The first example is the Mexican-American War. I talked about this a lot in the last lecture, and I'm going to talk about some different aspects of it here. So usually, remember, this war starts, Polk sends General Zachary Taylor into this disputed territory where American forces are attacked. This is probably a pretext by Polk in order to try to bait the Mexican forces into drawing first blood so that Polk can go to Congress and get a war declaration, which he does. And usually in war powers lore, this is the map that people focus on, the start of the war. And I want to focus on this map because this is what the United States ends up with at the end of the war, during the war and at the end of the war, that Polk coveted and ultimately conquered Mexico's northern territories, now much of the American Southwest. And one way in which he achieved that result but was by micromanaging military campaigns way more than any previous commander-in-chief had. Keep in mind that Congress, when it declared this war, it really didn't say anything about war aims. So Polk had a lot of power using military forces to shape those war aims, or using the diplomacy during the war to shape those war aims. He could have waged this as a war of very limited aims. He could have waged this as a war just over this disputed territory. Once the war started, though, Polk was thinking big, and even some members of Polk's own cabinet were caught off guard by his unilateral decisions to expand dramatically the war aims to include, as I say, capture and retention of the entire northern provinces of Mexico. I want to talk, though, about another underappreciated constitutional war powers issue here, though, that's also illustrated by this map, and that's the issue of military occupation. The question of who is constitutionally empowered to govern captured territory during the war. And this may sound like a pretty narrow issue, but the reasoning behind it is, the reasoning behind the answer is enormously consequential. So as US forces advanced westward through this Mexican territory, those forces needed to administer the areas they controlled. So in sending American forces on that westward offensive, Polk, in his administration, instructed the forces to assume governmental functions in captured territory. I also wanted to prevent an insurgency from arising. They needed to govern. And so exercising the discretion that those forces were given, for example, when they entered New Mexico, which was a huge piece of this territory. General Kearny, in charge of that westward advance, he stunningly, for example, granted American citizenship to the inhabitants. He declared that those who were disloyal could be tried and hanged. He issued new legal codes. He appointed civilian officials, including a governor and Supreme Court justices. So he did a lot to basically govern this territory in the name of the executive branch. Now, did the president have constitutional power to impose those occupational governments at all? In effect, he was ruling with no intention of giving up, by the way, more than 500,000 square miles of new land. And needless to say, this stunned some members of Congress who demanded answers, especially since, if you're looking for a textual hook in the Constitution, Article 4 gives Congress the power to enact laws for US territories. And you might think that's what applies here. Polk's argument was that because the international laws of war, law of nations at the time, as it would have been called, because the law of nations authorized, even required governance of occupied territories, those rights and responsibilities from international law flowed directly into the president's commander-in-chief powers. That basically the argument was that to understand what it means to be a commander-in-chief, one looks, at least in part, to international law and the customs of war. This was an argument, by the way, that Polk makes, and the Supreme Court in some post-war cases pretty much accepts. So the Polk administration's actions in occupied Mexican territory, to me, really stand out as a dramatic example of how the president can assert very expansive commander-in-chief powers by pegging them to international law. Here, international law wasn't just a constraint on executive power, it was the basis for a massive expansion of it.
Hey, Matt, so Congress, maybe caught off guard by these rather dramatic developments. Do they push back? Is there any serious pushback against Polk and his commanders?
Yeah, so there is, and I think that's also a really important part of the story. It's often lost because Congress doesn't impose the kinds of binding legislative restraints on the war that we'd normally pick up on as lawyers. But Congress's influence, I think, is very felt in the way the war is waged. He does get some pushback here, although Congress failed to involve itself much in setting war aims at the outset. Congress does begin to assert itself, especially as the war drags on. And there's a big reason for that, which is Polk had to come back to Congress for money. Polk and his congressional allies had assumed that this was going to be a quick war. But after a year of fighting and needing more money, Polk comes back to Congress, and in the debate about a funding bill to sustain the war for its next phases, Polk finds himself really squeezed between political opposition from multiple angles. There's political opposition to annexing any new territory beyond Texas, because this was especially among opponents of slavery who were worried that these would become slave states, and other political opposition to settling for anything short of just taking all of Mexico at that point. So Polk does end up getting his funding, but he really needs to now mind Congress. He may not have needed Congress, paid a lot of heed to Congress at the takeoff, but he needs Congress to help land this war. There's another way in which Congress also is able to, another big piece of leverage that Congress and especially the Senate has, which is that wars at this time customarily ended through peace treaties. which meant that the president would ultimately need 2/3 of the Senate to approve whatever negotiated settlements he came up with. And so this was going to give senators some leverage at the back end. I'd also just finally mention the way we know a lot about Polk's legal arguments with regard to occupied territory is because Congress demanded answers from him. It sent him a bunch of questions. It wanted documents. It wanted instructions that were given to General Kearney and others, and the president combined with them. So in the end, Polk's military success in occupying Mexico's northern provinces, as well as taking its capital, I think helped beat back efforts by members of Congress and the Senate to stop Polk's territorial ambitions and acquisitions. But congressional pressure to bring an end to the war also, I think, pushed Polk to perhaps more hastily accept treaty terms that he considered a bit imperfect in this example. The next example I talk about is the Civil War, and there's, we could do entire multiple lectures on war powers and the Civil War. I want to talk here about the Emancipation Proclamation. Lincoln takes many unilateral actions in this war, in addition to starting the war unilaterally against the Confederacy. While Congress is out of session, he unilaterally suspends habeas corpus, he increases the size of the army, he institutes a blockade, and many, many other actions. Those are at the beginning. I want to focus on something that happens midway through the war, which is the Emancipation Proclamation. And a lot of people know generally what it is, though the details are important. So it declares that as to slaves within states that are still in rebellion, quote, they henceforth shall be free, and the executive government of the United States, including the military and naval authorities thereof, will recognize and maintain the freedom of said persons, end quote. So it's issued as a military order. And one of the interesting aspects of the Emancipation Proclamation is that Lincoln claims to issue it as a military order by virtue of his commander-in-chief powers. And this is curious for a number of reasons, including that Congress had passed several statutes, the Confiscation Acts, for example, that had already previously taken some steps in the direction of emancipation. So Lincoln might have referenced them, but he doesn't here. He asserts that this is being issued in his commander-in-chief capacity. Now, how is this an act of commanding-in-chiefing? I think the main analytic move is actually one similar to Polk's move in military occupation, that he looks to international law, the laws of war, as the basis for understanding the scope of his commander-in-chief powers. And Lincoln argued that it was legal to take an enemy's slaves when they were being used as war material by the enemy, because doing so was necessary to the war effort. The use of slaves by states that were still in rebellion was sustaining the enemy's military effort, and freeing them would aid the Union's war effort. It was a military necessity argument pegged to international law regulating the conduct of war. So it's quite stunning that this act, an act radically granting human freedom on a massive scale, is done through Lincoln's commander-in-chief powers. Now, of course, this was quite controversial, both as an interpretation of his commander-in-chief powers, as well as his interpretation of the laws of war, especially among those who viewed property rights to slaves as sacrosanct. Many Confederacy supporters argued that the move was not really about military necessity at all, and that it violated longstanding U.S. positions on taking enemy slaves in war. They argued that this was really instead about using military violence to dismantle the social system of the South. But Lincoln has the power of the Union Army behind him, and in the end, his argument governs in this case.
Speaking of having the power that the Army gives you, this surely wasn't the only thing he did that was unilateral and didn't have express statutory authorization. So can you highlight some other things that were interesting that he I don't know if exploited is the right word, but
yeah,
but did under color of this authority?
Yeah, I'll talk about just a few. Like I said, we could go on and on about Lincoln and Civil War powers. I'll mention a couple, because he does take a lot of controversial unilateral moves, especially in this time period between the attack on Fort Sumter in April of 1861 and July of that year, because Congress wasn't even in session. So everything was unilateral. Congress comes back and blesses these things retroactively, but I'll mention two that really stand out to me. One was that in mobilizing the Union to wage war against the South after the attack on Fort Sumter, Lincoln unilaterally increases the size of the Army. And this is especially significant because this was something that many founders most feared, that the president would be able to create an army on his own, in part because they feared that a president who could do that might then abuse that power. But Lincoln does so in this case, and Congress buys that, yeah, this was an emergency situation, and signs off on it retroactively. The second one that I'll mention is Lincoln's unilateral suspension of habeas corpus. And more precisely, he delegates to commanders the authority to suspend habeas corpus and engage in military detention. And there's an especially famous showdown in Maryland, where a military detainee named Merriman challenges his detention, and none other than Chief Justice Taney, who is an opponent of the Union and is sitting in this case as a lower court judge, holds that the suspension of habeas is unconstitutional. That only Congress may lawfully suspend habeas corpus. Lincoln later defends his actions to Congress, and which ultimately supports him. But in the meantime, Lincoln just outright ignores Taney's judicial order in here. So those are two examples that I think are most interesting from that period. The last part of the presidential powers story I want to discuss is the Montgomery Ward seizure in World War II. And I call this just a half of an example because it leads to a case that gets mooted, and so we don't really get to sort of see this one play out to the end, but I think the argumentation is itself really interesting. So Montgomery Ward headquarters is pictured here on the left in Chicago, was once a behemoth of American business. During the early 20th century, it was second only to Sears, Roebuck and Company in the mail order retail business. They were like the Amazons of their day. And during the war, something like 2/5 of US mail order business went through Montgomery Ward. A big part of all manufactured products purchased by American farmers went through Montgomery Ward. So its functioning is critical to a lot of aspects of the American economy. On the right here is a famous picture of its domineering chairman and CEO, Sewell Avery, who, by the way, detested labor. I'll come to a moment on why he's being carried out by two soldiers. But on several occasions, labor disputes between Sewell and Montgomery Ward's management and labor boil over. And ultimately, unable to resolve them any other way, President Roosevelt, FDR, orders parts of the company and its headquarters seized in order to keep it running. He argues that Montgomery Ward is sort of critical to the continued effective functioning of our wartime economy. And in a particularly dramatic scene, Sewell refuses to leave. So he's actually carried out like lifted literally out of his desk chair at his office and carried out of the building by some soldiers. Now, where is the authority to get this? Where does FDR get the authority to do this? The best argument, though this is still a stretch, is a statutory argument that there was on the books at that point something called the War Labor Disputes Act, which allowed for the seizure of facilities, of business facilities that were deemed essential to the war effort. So there could have been a statutory argument that Montgomery Ward or parts of Montgomery Ward were essential war industries. My interest here, though, is that FDR's Attorney General, Francis Biddle, also makes an Article II presidential power argument. He says that in a time of war, when essentially the survival of the nation's at stake, this aggregate of powers, and by that he means all three of those clauses that I talked about before in Article II: executive power, commander-in-chief power, and the take care clause. The aggregate of those powers includes authority to take reasonable steps to prevent nationwide label disturbances that threaten to interfere seriously with the conduct of the war. In modern war, the maintenance of a healthy, orderly, and stable civilian economy is essential to a successful military effort. The case, like I said, it's litigated. It ultimately ends up getting mooted because the government withdraws from the seizure, returns it back to Sewell and its private managers. So we don't get judicial resolution of this case, but it's interesting to me first as a really, really expansive interpretation of Article II powers, expansive to sort of accommodate the expansion in what waging war means in this era of total war. I also flag it because this is a great illustration of the arguments that are a direct precursor to the Steele seizure case, where the factual circumstances and statutory context is different, but FDR and his Justice Department basically provide a roadmap, a legal roadmap for some of the legal arguments that Truman makes in the Korean War. So that brings us nicely back to the Steele seizure framework. We've talked about legislative war powers, which are immense. We've talked about presidential war powers, which historically are immense. When they're combined, they're super huge. Jackson says, yeah, they're additive. So immense plus immense is really, really immense. What about, though, when they conflict? And here's what Justice Jackson says when they conflict, is he says, when the president takes measures incompatible with the will of Congress, his power is at its lowest ebb. For then you basically subtract the president's powers from those of Congress. And courts, he says, can sustain exclusive presidential control in such a case only by disabling Congress from acting upon the subject. We have to look for presidential powers that are so conclusive and preclusive that we can sustain presidential action even in the face of a contrary statute without kind of bringing down the constitutional system. And the question, so when is Congress disabled from acting? What are these powers of Congress that are, these powers of the president that are so conclusive and preclusive that Congress is disabled from regulating them? For me, the image that kind of helps me think about it is a jelly donut. The donut here represents the president's war powers, but the doughy outer part is the stuff that Congress also has power to regulate. And the luscious jelly in the middle is the president's, is like the preclusive core. That's the jelly is the part in the middle that is solely the president's prerogative that cannot be interfered with by Congress. And like a jelly donut, the line between the dough and the jelly gets messy. I think the line between the president's core preclusive commander-in-chief powers and the stuff, the war powers that Congress can regulate, I think gets messy. If you're hoping, by the way, that in the remainder of this lecture, I'm going to clear this up for you, I'm very sorry to disappoint. Remember what Justice Jackson says in Steele Seizure, that, you know, he's talking both as a justice, but also as a former attorney general, that if you're looking for clarity in this area by looking at judicial precedent or even looking at prior presidential actions and argumentations or congressional actions, you're just not going to find a lot of clarity in this area. Some like to draw a line by saying the stuff on the battlefield is the president's sole prerogative, that if it's sort of battlefield decision making, that's solely for the president as commander-in-chief. Some criticize this as too narrow, some as too broad. Some would say, actually, Congress regulates a lot of things by imposing criminal justice rules, for example, on what soldiers can and can't do. It's regulating battlefield decisions. Some would say that actually the president has a lot more power to manage not just tactical battlefield decisions, but also exclusive power to dictate at a higher level of generality how the United States wages war. Perhaps one might say that at least Congress can't get into individual battlefield decisions. It can't say attack this particular target, or it can't veto attacking this or that target. That doesn't actually happen in the real world anyway. So as a matter of judicial precedent, as a matter of historical practice, I just don't think there are good, clear answers, but we can talk through some interesting examples of how this plays out. When does Congress's power to regulate how war is waged start to clash with the president's commander-in-chief powers as designated under Article 2 of the Constitution? And this really first arises in a big way in the Quasi-War with France. To remind you, this is the John Adams administration. The United States gets dragged into a European war, and French privateers begin raiding American ships and cargoes in the Caribbean, where there's lots of American commerce transiting. And in the resulting Quasi-War, there are actually very few battles, almost all of them at sea, but there are some interesting constitutional precedents that get set. One of them is that when Congress is debating whether to authorize the president, this is early in the war, whether to authorize the building of additional naval vessels. There's a debate between some who want to give the president more naval power, some who want to oppose giving the president any of this power. And so they start to debate some restrictions, like, well, what about if we give the president naval vessels, but we say he can only use them within American territorial waters, because what we really want to do is protect our ports. So restrict the use of them geographically. Others try to restrict the way that those naval vessels could be used. Okay, we'll give him naval vessels, but he can only use them for convoying, like escorting merchant ships through dangerous waters. And some opponents of those proposals said, wait a minute, those are the kinds of discretionary decisions. Where to send the vessel, how to use the vessel. That's the essence of being commander-in-chief. In a lot of cases, those kinds of debates don't really get definitively resolved. But we do have a couple of interesting cases that do result, including a Supreme Court case called Little v. Barine, which speaks a bit to this general issue. So in that case, Congress had authorized the capture of certain vessels under some very specific circumstances. And Chief Justice Marshall interprets Congress's statute very literally to authorize such captures only in those circumstances as a limitation on how the Navy could operate, and the court enforces the statute as limits on valid naval orders. Now, to some, this case stands for the general proposition that Congress may impose tight limits on how forces may be used, even in battle. Others, however, I think refuse to read the case that broadly, especially because it involved Congress's explicit constitutional power in Article 1 to make rules concerning captures on land and water. But it's at least one of the very, very few Supreme Court cases that kind of that wrestles with or deals with what Justice Jackson would say is a Category 3 case, where the executive branch is operating contrary to the express or implied will of Congress. So that's the Quasi-War. I'll fast forward to the modern day, where this issue comes up a lot in the war against al-Qaeda and its allies soon after 9/11. So this general issue certainly is raised in the context of a number of war-waging powers that the Bush administration employs. This includes detention of enemy combatants or enemy belligerents without trial, the use of military commissions to try enemy belligerents for war crimes. Note, by the way, that those kinds of actions, detention, military commissions, those are pretty traditional things that presidents do in war, going back to George Washington. Now, of course, the context in which the United States is doing those is very exceptional. We're talking now in 2001 and onwards about using them in the context of a sprawling conflict against a non-state actor, but the powers themselves are sort of ordinary compared to, say, assertions of power by Congress or presidents in the Civil War or World War I that I talked about earlier. But what I want to focus on here is not just the use of those powers, powers of detention, harsh interrogation techniques, the reliance on military commissions, and even forms of electronic surveillance to capture enemy communications. For my purposes here, I want to talk about the argument among some Bush administration lawyers that not only was the president authorized by virtue of Article 2 of the Constitution as supplemented by Congress's authorization of force, not just that the president was authorized to do these things, but authorized to do them free of any legislative interference, that these kinds of activities were in the jelly, that these were activities that Congress could not constitutionally interfere with because detention, interrogation, military commission, these were the kinds of discretionary decisions about how to engage enemy forces that were constitutionally and exclusively granted, went the argument, to the president as commander-in-chief. Now, let me say that is a very extreme argument. It is one that was repudiated even by the Bush administration, by the Justice Department, and the other branches of government have in various ways pushed back explicitly or implicitly against that kind of reasoning. It still leaves, though, I think, a lot of uncertainty about how much jelly is in the core of the donut. One reason why there's a lot of uncertainty there. And one reason why historical practice, I think, is very hard to decipher in this area is because if you only look at court cases and you only look at statutes that are passed and applied and upheld, I think you miss a lot of the action. That at its best, Congress can wield its oversight powers. And here I'm coming back to my point from early in the lecture about Congress's implied oversight powers. Congress's oversight powers, as well as informal powers that Congress or committees or even individual members can exercise to influence the conduct of the war. Going to the media to argue, holding hearings, using the leverage of nominations requiring Senate confirmation, using requests for funding, these kinds of things, as well as using high publicity hearings as a way of drawing public attention to the way in which wars are being waged. This, I think, is a very significant body of congressional practice for influencing, for constraining how wars are waged. It's action that doesn't necessarily show up in the body of stuff that we as lawyers tend to focus on, cases, statutes, and so on. But I do think it's critically important, and in my view, it's an area of congressional practice where Congress really ought to be upping its game. I would like to see less emphasis on the issue of war initiation, more emphasis given to Congress's powers to oversee and influence how wars are waged. And so let me just end this point by just saying, I think if placing too much emphasis on Congress's role in initiating war kind of lets Congress a bit off the hook in its really important role in overseeing how wars are waged. With that, let me turn to the last issue I want to cover, which is war termination. When do wars end? And for our purposes, when do war powers end? And there's not just that substantive question, but a second order question of who decides when wars or when war powers end. One reason why this is important is that once government has new powers by virtue of war, it may be pretty reluctant to give them up. And so this is a pretty important question. The short answer to when do war powers end is that war powers terminate when the political branches say they've terminated. I'll get to how I get to that short answer in a moment. Let me say this wasn't really a huge issue at the founding, because back then, in addition to the fact that war powers weren't as extensive as the kinds of things I was talking about in the Civil War and world wars, but also because wars ended with peace treaties. The picture on the left is a picture of the signing of the Treaty of Ghent, ending the War of 1812. And so wars ended when you had a peace treaty. That was kind of a nice, clear, bright line ending for the end of wars. I do want to talk through some examples, though, to make the point that the emphasis today on when is the war against al-Qaeda going to end, that is not an entirely new issue by any stretch. So let me give a few examples. The first example I'll talk about is the Civil War. Major combat operations ceased with the Confederate Army's surrender at Appomattox in April of 1865, but war powers continued for years afterwards. And that's partly because of continued fighting by some members of the Confederacy, but also because war aims hadn't yet been achieved, namely readmission of the Confederate States. Key aspects of Reconstruction were also based on a continued reliance on constitutional war powers. And so I'd say that in the Civil War, there wasn't a clear end date of war powers. They sort of peter out over the course of several years, partly because military reconstruction itself tapers off, and partly because other constitutional bases for government action, especially the 14th Amendment, come into effect. So you have sort of a tapering off of war powers without any one clear end date to the use of war powers, I'd say, in the Civil War. World War I is interesting in part because we talked earlier about just how immense Congress's war powers were. Vast control over the economy, vast delegation to administrative agencies. So when does that spigot of war powers turn off? The armistice happens on November 11th, 1918. The fighting stops, or almost all of it stops on that date. But the United States certainly hadn't achieved its full war aims then, right? We think about Wilson's 14 points. He's talking about the war to end all wars, the remaking of a new international legal order. That certainly hadn't been achieved by November of 1918. This issue, though, so how do we mark the end of the war? Is it when the fighting ends? Is it when war aims are finally achieved? This issue gets litigated, and there are a few Supreme Court cases, including a pair of them that are about, of all things, wartime prohibition acts, liquor restrictions. This always amuses me, by the way, because I sort of feel like, talking about World War I and war powers, you say, Congress passes the Sedition Act. People say, oh, well, yeah, sure, that sounds reasonable. Restrict the press, restrict opposition to the war. National draft, sure, that sounds reasonable. But take away people's liquor, and all of a sudden, yeah, ho now. Wait a second. So we have litigation over the war termination issue arising out of these wartime prohibition acts, and these are interesting because here, we're talking not just about continued application of laws that were passed prior to the armistice, but also Congress continues to enact some new laws using war powers even after the armistice. And essentially what the Supreme Court says is war termination and war powers termination is not an issue of fighting. When the fighting stops, you need really to look to the political branches, and when the political branches have made a determination, a formal determination that war and war powers have terminated. Now, this raises another issue in World War I, which is, well, what kind of political branch action counts? As I said before, it used to be peace treaties. It used to be that the diplomats would go off, negotiate a peace treaty, come back, Senate would provide advice and consent, and boom, we're done. In this case, though, the Senate rejects the treaty. Wilson comes back from Europe carrying the Treaty of Versailles, and the Senate rejects it. So this leads to a debate about whether there are other ways besides peace treaties in which war powers can be turned off. And the answer that they come up with through practice between the executive branch and Congress, which is, I think, a sensible one, is that Congress can terminate wars and war powers with a joint resolution. It wouldn't really make sense to require 2/3 of the Senate always to approve the ending of war, because you sort of want war power. You sort of want to make it easy for Congress to turn off war powers. You don't want to make it too hard, especially if the government is likely to be tempted to hold on to war powers. So joint resolution becomes a mechanism for terminating war powers. And then, that then leads to the last example I'll talk about here, which is today's so-called forever wars based on the 2001 authorization of the use of military force, AUMF. One context in which this arises especially is detention at places like Guantanamo, because that results in habeas litigation. So we actually have some judicial reasoning on this issue. The question is, Okay, by virtue of the fact that we're at war with Al-Qaeda and its allies, the president may detain enemy fighters for the duration of hostilities. When does that detention authority expire? And one case in particular in which this has been litigated pretty thoroughly is a case called Al-Alwi, and there's a DC Circuit decision rejecting the claim that the war has effectively ended already, at least for the purposes of the petitioner's detention. And the court in that case, like in the World War I cases, says the question of whether the war has ended is a question for the political branches. It's war termination is a political act. So this raises, I think, interesting questions about whether courts would ever come in and say, no, absent even absent a clear political act, we as a judiciary are declaring the war over, or whether perhaps courts might start to interpret that political act requirement maybe a little more loosely. Bobby, I'll turn this over to you because I know you follow these Guantanamo habeas cases closely. Do you have any thoughts about how this might play out there?
Well, it's interesting. Thanks for that. I agree with your description of it. With Al-Alwi, what's interesting is that, so he's captured in Afghanistan as part of the original American intervention in fall or late 2001. And it's certainly true that the nature of the U.S. military role there has evolved over time. And there have been moments, including a key moment in the Obama administration, where the rhetoric of how the U.S. ongoing role in Afghanistan has been described began to de-emphasize the combat function, and that kind of opened the door towards an argument that maybe there's really not an armed conflict there anymore. The Al-Alwi decision basically says, look, whatever may have been said, the fact is there's a lot of shooting still going on. There's ample evidence of ongoing patterns of attack. So we're not there yet in terms of getting to a place where the facts on the ground just don't seem compatible with a claim by the political branches, whether express or implied, that the armed conflict is continuing. The court, both there and in one of the key earlier Supreme Court cases, Ludicky from World War II, there's a gesture towards the possibility that if you had an extreme enough gap between that implied claim that there's still war and what's really happening on the ground, under the most extreme circumstances, maybe the court would get involved. But whenever, like in Ludicky itself, when the court talks about this, the court says, that is such a fraught question, such a dangerous question that we're not going to talk about that unless and until we absolutely have to. And we don't have to in that case. And Al-Alwi says the same thing, that whatever else is true, this isn't a hard case. It's worth noting that the petitioner sought Supreme Court further review, but cert was denied. Justice Breyer issued a statement with the denial of cert. This was last summer, basically saying that it's been many years since the invasion of Afghanistan, and at some point we've got to return to this question of whether the detention authority that we thought came with that still obtains. And I think that is sort of a way of saying we may yet, maybe we're already, I think for Breyer, we're already at the point where we ought to revisit it, and maybe the court should exercise some independent judgment. But notably, that was just Breyer saying that, and there's no indication that there's a current majority of the court that feels the same way.
Yeah, great. Thanks very much for that. And yeah, I agree with your take in reading at least some of these early tea leaves from the Supreme Court, but leaving a big question mark. I think the Supreme Court, and courts generally have not wanted to close the door forever on possibly looking at this question, but at least to date, they have not second guessed the political branches on war termination issues. So let me end with a few final sort of closing points. First, for much of our history, war powers, especially legislative ones, have expanded dramatically as war has changed. So what does that mean for the stakes of war initiation powers? In lecture one, I said, originally, war powers were at least as much about domestic governance as about foreign policy. This was especially true in the Civil War and World War I, where the existence of a war gave the government, the national government, vastly more power than it had in peacetime. That's a bit less of a problem, or a bit less of an issue now, especially for small conflicts, because as I said, the peacetime national government has just so much more power than it did in earlier periods of our history. Query what a great power war would look like. I hope we don't face that, but what might a future war, a major war, bring, and what kinds of powers might the government assert in that war, including, for example, the need to take control of digital information. And let me just end with a note about the virtues and dark sides of everything that I've just talked about. I talked at the beginning about a clash of two visions of the Constitution in war. One is a vision of flexibility. The Constitution needs to move and bend and flex to deal with the necessities of war as they arise, versus rigidity, that the government is prone to abusing powers in wartime. And so it's all the more important, perhaps, in war that we maintain some rigidity of constitutional rules and process. I think over time, generally speaking, the flexibility version of that argument has won out and dominated the rigidity version. Not always, but mostly, especially over time, flexibility has won out. That flexibility has allowed us to win really important wars: the Civil War, the war against fascism, the Cold War. But overall, this is in many ways a really great story. That flexibility, though, does come at some costs, like Japanese internment, to give an example, in which all three branches played a role in dangerously unleashing war powers at home. So a challenge always for the American constitutional system has been how to protect itself without destroying itself. So I'll end on that note. And Bobby, thanks for having me.
Matt, that was fantastic. Thank you so much. I'm going to go ahead and say that I've learned a huge amount from the sequence of these 3 lectures. I've been studying this stuff for a long time. A lot of these episodes, I didn't know some of these details. And I've also never really had it all presented in this sort of sequential, systematic format. And it really makes the whole thing come together. And I realize more than I did previously how problematic it is to try to understand it by looking at just one of the streams within the many. So thanks a ton for that. And for those who are watching either live or remotely, these are just some of the lectures that Matt and I are curating as part of a growing series of national security law primers and backgrounders, webinars, lectures, however you want to think about them. We hope you find them useful. We hope you like the format. We're happy to get feedback. And we look forward to seeing you again on some of the other episodes later on. With that, I'll say goodbye to everybody. Thank you.
Thanks, Bobby.